Ethical Perspectives on the News is produced by the Interreligious Council of Linn County, which is solely responsible for its content. The views and opinions expressed on this program do not necessarily reflect those of the staff and management of KCRG TV9.
Welcome to Perspectives on the News. My name is Bob Rush, and I'm pleased to announce an outstanding panel today. We have with us Libby Slappey, Professor Todd Pettis, and Maggie DeWitte. And I'd like to ask each of our panelists to share a little bit more about their background. Libby, would you begin, please?
I'd be happy to. Thank you, Bob. Appreciate being here. I'm Libby Slappey. I am retired, but spent a good deal of my career in nonprofit fundraising, and at one point was both a volunteer for and a staff member for Planned Parenthood in Cedar Rapids. Also instructive to my experience was 16 years as a residence hall director, working with college students.
Thank you. Todd?
I'm Todd Pettis. I joined the faculty at the University of Iowa Law School back in 1999 and have been teaching constitutional law for most of that time. And Roe v. Wade and cases of that sort are part of the things that I have the pleasure of teaching every year.
Thank you. And Maggie, please share a little about yourself.
Yeah, I'm Maggie DeWitte. I'm the Executive Director of Iowans for Life. I've been with IFL for a little over 11 years. And prior to that, my history has been in foster care and adoption work, as well as group homes and other nonprofit and social service arenas.
Thank you. Our panel is ready to go. We're going to be discussing abortion, reproductive rights, and where Iowa law is and where it may be going. Who would like to take a little stab at how Iowa was before 1973?
Well, I can just say something as a general matter because I'll be talking about most of the country at the same time. 1973, of course, it's a well-chosen year to start the conversation. That's the year Roe versus Wade is decided, and it was the Texas abortion law that was struck down that day. But it wasn't just the Texas abortion law. That was the law at issue in that particular litigation. But the law that was on the books in Texas at that time was very typical. It's basically the same as what Iowa had on its books. And I don't know the precise count, but 35, 38 states, something like that, had laws that were just like Texas's. And then some states that had laws restricting abortion, but under different terms. And so across the country, including in Iowa, the norm was that abortion was strictly prohibited unless the life of the woman was at stake. That was the case in Iowa. It was the case in Texas as well.
Okay. And Maggie, what were abortions taking place before Roe versus Wade, even though they were unlawful?
Yeah, certainly abortions were taking place. I know that there's a lot of misinformation about what happened prior to Roe. And a lot of a rhetoric about back alley abortions. But interestingly enough, a former Planned Parenthood director, Mary Calderon, she said that over 90% of all abortions pre-Roe were done by doctors. So they were done in safe facilities by doctors, but they were rare, definitely, before Roe came down the pike in 1973.
And Bob, I'd like to comment too that in 1970, that was the year I was a freshman in college, and there was a woman on my floor who was a preacher's kid, as we called them, and she got pregnant and she chose to terminate the pregnancy. And so I recall all too vividly what she went through, because we were in Iowa and the friends of hers on her dorm floor pooled money for her to both buy a plane ticket and then for the procedure itself, which took place in New York. And we were so scared for her to make that trip by herself. Now she was having it performed. Abortion was legal in New York, and so it was a legal procedure performed by a physician, like Maggie said. But she was by herself, and we've always wondered what it would have been like if she hadn't had to travel, if she could have stayed here in Iowa.
Todd, what would you say the precise holding in Roe versus Wade was?
Well, I'll see if I can do it just in a quick 60 seconds or so. It found, first of all, that in the Constitution, there are some rights that are unenumerated that get strong judicial protection, and the right to terminate a pregnancy is one of them. The court had previously found a right to use contraception. It had previously found a right to raise your children in the way you see fit, such as choosing where to send them to school and so forth. And so the court found here that the right to terminate a pregnancy within certain limits is a strongly protected constitutional right. And it divided pregnancy up into stages. And the point of viability, the point at which the fetus is capable of surviving outside the womb, albeit even if medical intervention is necessary, if the fetus can survive outside the womb, after that point, so the latter part of pregnancy, the Supreme Court said a state can, if it wishes, ban abortion altogether, except in cases of life or health of the woman. Prior to viability, however, the state could not intervene in an effort to protect fetal life. There was a part of that period where the state could intervene in order to protect the woman's health, but for the most part, that time period prior to viability, the state's restrictive powers were greatly limited. It was only after viability the state could step in a very strong-handed way and ban abortion, except, as I say, in cases of life or health of the woman.
Maggie, what was the Iowa landscape like following Roe versus Wade?
Well, I would like to add to that whole viability statement that was just talked about, because I think when you look at when Roe was passed, viability is such an arbitrary standard. And at the time in 1973, when we looked at viability, that was 28 weeks, and now we're looking at 23 to 24 weeks because of the tremendous amount of medical advances that we're seeing in terms of viability. And really, when you look at it, I mean, a 1-year-old, they can't survive without intervention. So it's a very arbitrary term. And so, when you look at that and you look at the medical advances that we have now, viability becomes a very different term.
Mm-hmm. What was Iowa like after Roe versus Wade? Was it any limitations then on getting an abortion?
We haven't had here in Iowa limitations on abortion in any real way until actually in the 2017 legislative session, when we were able to pass a 20-week abortion bill. And that stated that after 20 weeks, you could not have an abortion in Iowa. But prior to that, we had some other parental notification laws, some of those kinds of things. But we weren't able to do any real restriction on abortion until we were able to get that 20-week abortion ban in 2017.
Right. We'll get a little deeper on those issues in a minute. I just wanted to try to get some perspective, Libby, on what the Iowa situation was post-Roe.
Yeah, I appreciate that Maggie mentioned the parental notification piece, because I need to talk about parents for just a minute. Unintended pregnancies, especially among teenagers, are very commonplace, as we know. And back then, it was actually in 1979, there were plenty of teenagers who were seeking contraceptive services in Cedar Rapids, but there was only one place they could go and have the privacy that they asked for, and that was to a Title X clinic that was affiliated with St. Luke's Hospital. And it was in 1979 that Planned Parenthood began a clinic in Cedar Rapids because we knew teenagers were sexually active for as many as 2 or 3 months before seeking contraceptive services. So we knew it was important to be able to offer a confidential place where teenagers could get contraception. Now, Maggie mentioned parental notification, and that's just for abortion. But for a teenager or a minor to be able to seek contraceptive services, we knew that that was critical to them preventing an unintended pregnancy and thereby negating the need for an abortion.
Maggie, your organization was active in helping get past the so-called parental consent law for an abortion. Is that correct?
Well, it's actually a parental notification, which is different than consent.
Yes.
So that was passed some years ago, and that basically said that the parents of a minor would have to be notified prior to an abortion. However, there are waivers or judicial bypass in which minors are able to bypass that law for whatever reason to get before a judge to state that they would like to have an abortion if they are a minor.
That would include things like incest or pregnancy as a result of rape.
I would assume so. Unfortunately, we don't have any data on how many waivers are actually granted and what the reasons are.
And there have been cases, Bob. There was a young woman in the state of Indiana when there was a parental consent law in place. And she did not want to disappoint her parents because she was a star student in every way. She didn't want to disappoint her parents by having them know that she was pregnant. So she sought to terminate the pregnancy out of the state of Indiana, and in fact chose an illegal abortion and sadly died from that. And it's interesting that her parents then really took up the banner against parental consent and notification laws because they lost their own daughter because of that.
Now, other limitations, does the law, Maggie, provide or require an ultrasound?
Yes, it does. It does not require the woman to look at the ultrasound, but it does require that an ultrasound be performed and she be given the option to view it should she choose to.
What's the rationale behind the ultrasound law?
Well, we do know a lot more in terms of medical technology than we ever did when Roe was passed. And I believe that the ultrasound is sort of the window to the womb. And we do know that when women do have the opportunity to view that unborn child in her womb and see that baby and realize it is not just a blob of tissue or a clump of cells, but it actually is a living human being with a heartbeat. We see over 80% to 90% of women will choose life for their unborn child when they get to see that ultrasound and see the humanity of that child growing in the womb.
Excuse me, are there any medical tests that are required by the legislature of men? Maggie?
Are you asking me?
Yes.
Medical tests for men?
Yeah, required medical tests for a man.
Regarding an abortion?
Regarding anything.
That would not be I'm not a medical doctor. That wouldn't be my area of expertise in terms of what medical tests are done for men.
Yeah. Todd, any thoughts as far as what's mandated by law as far as a woman versus a man?
Well, I'm 55. I'm trying to think if there's been a time when a doctor has said, now the law requires me to do X. I don't think so. Now, when I go into a doctor and say, here's what I want done, I would expect there to be some legal constraints on what the doctor needs to do, either as a matter of law or to avoid liability. The law is going to say, okay, now if you're going to do this procedure for pedis, there's a right way to do it and a wrong way to do it. I'm sure that there's undoubtedly informed consent. There are informed consent. I've had, medical procedures when the law requires that I'd be advised of certain things before proceeding with the procedure, and the hospital is required to go through that for me. So, nothing, not an ultrasound per se, but there are times I think where our legal regime requires men and women alike to be advised of certain things, and that certain procedures be followed before some kind of medical test or procedures carried out.
Libby, any approaches to reducing the number of unwanted pregnancies?
I think that we need to look at terms here. Unwanted, unplanned, unintended, all of those things can occur. And in many of those cases, a woman can consider terminating the pregnancy. I know I spoke just moments ago about teenagers and unplanned pregnancies. We were all teenagers once. We remember how we thought nothing could ever happen to us. When my niece was 14, she had an unintended pregnancy, and she carried the pregnancy to term and, has a 30-plus-year-old son now. But I know for her, she didn't think that it could ever happen to her. And ironically, now, lo, these many years later, she didn't get vaccinated, and she ended up with COVID and ended up hospitalized. She's hospitalized right now, as a matter of fact. And when I talked with her about it, she said, well, I just didn't think it could happen to me. So I know that Maggie and I probably share similar thoughts, that if we could do something at the front end to not have these unintended, unplanned, unwanted pregnancies, that would help avoid the choice for abortion. Maggie, I'm putting words in your mouth maybe, but I'd be hopeful you'd agree with me.
Thoughts, Maggie?
Certainly. And that's, what one of the things that our organization is about is education. And, that really is the key. We are in the schools, along with a lot of other pro-life pregnancy resource centers across the state, educating young people on the dignity and the value of their life and how they have worth and value. And just talking about those basic terms to these young people across our state, that's a big part of what we do. And we hope that will have an impact on decreasing that need to make a decision where you're ending the life of your unborn child.
Let me move ahead to the year 2018, I believe. The Iowa Supreme Court, Todd, came down with a decision in a case called Planned Parenthood versus Reynolds.
Yes.
Give us an overview of that?
Sure. Let me say something about what federal law said at the time, which will help us appreciate what the Iowa Supreme Court said at the time. We've talked about Roe versus Wade, which was 1973. There's some important ways in which Roe versus Wade is no longer good law and has been replaced by what the court said in a case called Planned Parenthood versus Casey, which was decided in the early 1990s. And so let me say what Casey said, and then I can tell you what the Iowa Supreme Court said, because that was the backdrop against which they were working. What Planned Parenthood versus Casey said, interpreting the federal Constitution, is that Roe versus Wade was correct with respect to restricting abortion after the point of viability. The point, again, where the fetus can survive outside the womb, even if some medical intervention is necessary. So that part didn't change. But before viability, Planned Parenthood versus Casey said that Roe versus Wade had undervalued the state's interest in protecting that fetal life. Because I had said a little bit ago that prior to viability, Roe versus Wade didn't allow states to really restrict abortion in any way with an eye toward preserving fetal life. And Planned Parenthood versus Casey said, no, states have got more leeway than that. And they adopted something called the undue burden test. And this remains federal law today and is federal law that's currently up in front of the United States Supreme Court for another look. And what that says is that prior to viability, a state can restrict abortion in ways aimed not necessarily at trying to protect the life of the woman, but trying to protect the life of the fetus. And so, 24-hour waiting periods, things like that, it's not about protecting the woman necessarily, but measures aimed at trying to persuade the woman who wants an abortion pre-viability to change her mind. So long as that doesn't impose an undue burden, those laws are permissible. And an undue burden is a law that has the effect of placing a substantial obstacle in the path of the woman. So when a state restricts abortion pre-viability, the test is, under federal law right now, well, is that restriction imposing? It's okay to impose an obstacle. It just can't be a substantial obstacle. So that's the backdrop, and that remains the law today. So the Iowa Supreme Court in 2018 was asked, well, what about the state constitution? What about the Iowa Constitution, and what does it say about abortion? And, there's a lot of possibilities. The court could say, well, it doesn't say anything at all about abortion. Or it could say, well, it protects abortion just to the same degree as Planned Parenthood versus Casey. And what the Iowa Supreme Court said is that the Iowa Constitution does protect the right to terminate a pregnancy and actually protects that right very strongly at the Roe versus Wade level. Okay, and so this undue burden test, substantial obstacle, those ways in which Planned Parenthood versus Casey had given states greater regulatory leeway, the Iowa Supreme Court said that, well, under the Iowa Constitution, women actually have stronger protection. And so at any point in the pregnancy, a state that wants to restrict abortion has to pass something called strict scrutiny. And for those who've studied law, they know that strict scrutiny is a really demanding standard where the state carries a very high burden of persuasion to show how necessary this restriction is to achieve some kind of compelling state goal. And that remains the law right now. And so in Iowa, under the Iowa Constitution, women actually enjoy a very strongly protected right to abortion. And even if the United States Supreme Court were to overrule Roe versus Wade or Planned Parenthood versus Casey, here in Iowa, so long as that Iowa Constitution remains interpreted the same way, and so long as it's not amended, women will still have a very strongly protected right to abortion.
And Maggie, your organization is involved in an issue to override or to change that decision. Would you expand on that?
Sure. So what happened is it started in the 2017 session when we passed the 20-week ban. We also had a 72-hour waiting period before you could have an abortion, and that's the part of the law that was gone up the pike through the court system. And then that next legislative session in 2018 is we passed the first in the nation heartbeat bill. And after that was passed and signed into law by Governor Reynolds, the Iowa Supreme Court came back with their ruling on the 72-hour waiting period that said it was unconstitutional, an undue burden for women, but furthermore, there's a fundamental right to abortion in the Iowa Constitution. And that heartbeat bill, the judge used that ruling to declare a heartbeat bill unconstitutional, and so it therefore never went into law either here in Iowa. And so our group, along with others in the pro-life movement here in Iowa, have joined together to pass a Protect Life Amendment, a constitutional amendment, that states there is no fundamental right to abortion in our Iowa Constitution, and Iowans should not have to pay for abortion.
Libby, would you have any comments in regard to these efforts to amend the Constitution?
Well, I'd like to ask Todd on the Roe decision. Wasn't privacy a significant part of that decision as well? Or am I?
Well, yeah, no, you're absolutely right. Of course, the Roe versus Wade found a right to privacy. That's kind of the label that they gave this right that's not spelled out in the text of the federal Constitution, but the United States Supreme Court said, nevertheless, it is there, and that remains true as the federal Supreme Court reads the Constitution today, and it covers things not just abortion, but it includes a cluster of, you kind of think of them as family and family formation and intimacy rights. So today, do you have a federal constitutional right to have access to contraception? Imagine a state that wants to criminalize contraception across the board. They want to ban the sale or the use. That law would be invalid. It'd be invalid under this right to privacy because the state would have to show a very strong, compelling reason why for the ban, and they wouldn't be able to show it. Your ability to raise children as you see fit. The state wants to come along and tell you specifics about how to raise your kid, and you need to go out and exercise them twice a day, and you need to teach them such and such at home and so forth. And the parent says, it's my child, I'm going to do what I want. The parent's going to win that case, at least the cases that I just described. And that falls under this kind of umbrella of the right to privacy, that there's a domain of there's areas of your life that the state is not to enter unless they have a really powerful justification. And that remains true under the federal Constitution. They've reinterpreted that right to privacy at the federal level to give less protection than they had before. But that is the grounding of the federal right.
Thank you. We're getting close to the end of our time, and we certainly could spend many more minutes talking about these very important issues. I'd like to give each of our panelists a chance to wrap up their thoughts. Libby, would you go first, please? And then,
sure.
Then.
Thank you. I couldn't help but reflect as Todd was talking. I couldn't help but reflect on the sort of irony. We have these HIPAA laws. And, all of us have been to doctor's offices where anytime we make a visit, we have to sign something that says we understand, the privacy and HIPAA laws. And yet, as a woman in the state of Iowa, if I wanted to terminate a pregnancy, I've got the state legislature telling me, they've passed the roadblocks to keep me not necessarily from doing that, but to slow me down from doing that. And like you alluded, Bob, what are the laws that impede on men's health decisions?
Maggie, do you have any closing thoughts? We only have less than a minute.
Yeah, I would say that our organization has worked hard to educate Iowans on the sanctity of human life from fertilization to natural death. Abortion is not health care. Pregnancy is not a disease. And abortion hurts women, pure and simple. It hurts women on every level.
Todd, should we pay attention to what the Supreme Court may be doing later this year?
Very quickly, December 1st, circle it on your calendar. That's the day the Supreme Court is going to hold oral arguments in what might be the biggest abortion case of this generation, December 1st.
Thank you, panelists. It's been a terrific conversation. I wish we had more time, but thank you all for watching and being with us.
Thank you.
Thank you.
Thank you.